Hello, good afternoon, and welcome to today's session on property matters, supported by Accent Radio, as brought to you by Accent Realty. So today, as we have always done, we'll be discussing some issues concerning property transaction, and today we are going to be looking at inheritance, the application of customary law in today's Nigeria. So our topic again is inheritance, the application of customary law in today's Nigeria. Now, one thing you may want to ask, what is customary law? Customary law refers to those sets of laws or rules which guide the affairs of a particular people, ranging from the lifestyle, traditional beliefs, and practices in a particular place. This practice also extends to inheritance. It's at the passing of a parent, the way and manner the property the parent or a deceased person had before the passing, how it will be distributed, is what refers to customary law regarding inheritance. Now, with the advent of English law or new legislation, that is laws passed by either the National Assembly at the federal level or the State House of Assembly, we have seen cases where we now have WIS laws, which regulates how property are to be distributed by different persons. Though these laws, they apply differently to different states, because each state of the federation has its own peculiar law that is peculiar to its people, because each state has different ethnic groups. So when they are making those laws, they put the cultural practices of those states into consideration. But however, the making of those laws or passing of these laws does not hinder the continuous practice of customary law in different parts of Nigeria. As we already know, Nigeria has over 400 tribes. So these different tribes, they have their own peculiar customary law that applies to the distribution of the estate of a deceased person. Now, it is instructive to know that though most people today now subscribe to the use of the state laws or laws as made by the National Assembly in the distribution of their wealth through the instrument of a will. Now, a will is a document which contains the wishes of a person on how his estate should be distributed among the persons he desires to inherit his property. Now, for a will, the maker determines who gets what and how is to be given to such persons. But in customary law practice, those property which the person may have acquired during his lifetime is shared according to the cultural practices of his people. It doesn't matter where he lived at a particular point in time, but as long as he remains a member of that particular community where he is from, as long as he has not renounced his cultural beliefs of his people, the cultural practice as regards inheritance will apply. Now, for these cultural practices, this customary law, to apply to inheritance, there are certain things to be put into consideration due to the advent of different enactments, different laws that have been made by the states and the federal government through the National Assembly and the State Houses of Assembly. Now, for customary law to continue to apply in today's Nigeria, that customary law practice must not be repugnant, it must not be against good conscience, and it must not be against public policy. What does this mean? It means that when you are practicing any form of customary practices or customary law that you believe and hold on to strongly, when it comes to inheritance, it must not, the law or the customary law practice must not in any way deprive any member of a family of his or her inheritance, maybe on the basis of sex or whatever ground, as long as the customary practice does not in any way deprive a particular person of a share which ordinarily he should be a partaker of, then that law, customary law, will continue to apply. For instance, maybe the customary law of a particular community states that when a man dies, his sons and his daughters are to share the property equally. Then, if that is the case, that customary law will continue to apply even where you have different laws, with law in different states. But however, where it is stated in or it is practiced in that particular community that when a man dies, his daughters are not entitled to inherit his property, or the son should take everything while the daughters and others, or the other siblings, should be left empty-handed. Such practices will not be upheld. So if anyone who is affected by this stringent customary law practice approaches the court will always hold in his favor. So for the customary law practice to continue to apply in today's Nigeria, that customary law must be one that accommodates every person that is entitled to share in the estate of a deceased person given appropriate share. The next one you may want to consider, which may determine the applicability of customary law in today's Nigeria, is the Sharia law. Now, some of these laws, the states of the federation have accommodated the practices in those different areas. Now, the Sharia laws, despite the practice of the different enactments in the states, states that a man cannot distribute all his wealth the way he wants it. So the practice in Islam is that a certain percentage of the man's property must be reserved for the benefits of the members who are entitled to share in his property. That's members of his immediate family. It could be the children or the wife or something. But as it is provided under the Sharia law, certain percent, which is usually 10%, must be reserved. So maybe a person who is a Muslim now, or has been a Muslim for, let's say, 10 years before his death. Now, upon his death, maybe he made a will. The will he has made, if he decides to distribute all his wealth and give it out to strangers, such will be vitiated. That is, it will be null and void, because the customary or the Sharia law practice is that at least 10% must be set aside for the benefits of the immediate family members. That is one thing we must take note of. Now, if a particular person decides, because my children have done certain things, I will not give them a share, or because a particular person who is not a member of my family has been so good to me, you decide to give what ought to come to your children as members of your family, those who are dependent on you. You decided that, okay, because one thing led to the other, you are disinheriting them through the instrument of a will. The law states that you must set aside 10%, and this is the position the court has also upheld in a plethora of cases. So when you are stating that, okay, because we are now in a civilized world, customary law does no longer apply. If you are a Muslim, you must take note of these parts. At least 10% must be set aside for the benefits of those who are solely dependent on you. So in Kwara State, for instance, it is clearly written in their state with law that 10% must be reserved. So if you have been a Muslim and you are from that state, you must always have it at the back of your mind that 10% goes to the members of your family. Even if you have billions of naira, you want to distribute it the way you want, certain percent must remain that you cannot deal with whichever way you decide. This is how Sharia law continues to operate in today's Nigeria. Now, I also stated earlier, some customs have been recognized by the law. Now, if you look at some cultures in Nigeria, they determine what goes to Mr. A, what goes to Mr. B, and what goes to Mr. C at the passing of the parents. Most times, what we consider is the man of the house who acquires property. Now, if a particular member of the house, who usually maybe the father in this instance, let us put it that way. Now, if the father has passed, there is a certain property that must go to certain persons as a result of being social position in that family. Now, if you look at the Benin culture, for instance, they have this Igyobe traditional practice. Now, this Igyobe practice says that where a man lived his life and died and was buried, that particular house belongs to the eldest son. Now, if Mr. A has lived all his life, he built a house, let's say 5-story building in a particular area. After he has lived his life there, he died and was finally buried. That particular house belongs to the first son of that deceased person. So the law that is being practiced in that state cannot stop that first son from inheriting that property. The only condition there is that that son must have performed the burial rites of his father for him to have that inheritance. So this does not mean that other members of the family cannot have a share, but he acts as a trustee. This is when there's only one property. If the man was only able to build one property in his lifetime and that is all he has, the first one cannot chase away other members of the family. Now, why do persons still continue to hold on to this practice? That house that the man lived and died and was buried serves as ancestral home to all members of that family. Wherever they may be tomorrow, they will always come back to that place as their family house. So the traditional belief is that the members of the family should also have a place they can always come to as their family house. That's one of the justification that has been given for that cultural practice, that Igbo practice. Now, the court has upheld that position that customary practice that allows the first son to inherit the father's house is not repugnant. Therefore, it should be continued to be practiced by the Benin people. Now, even if you lived outside of the states, or maybe you are not a Benin person by origin, but you have maybe by conduct or through assimilation and acculturation, you decided to be a member of Benin Kingdom and you have been accepted, the Benin culture will therefore apply to you the same way it will apply to those who are original members of Benin Kingdom. Now, another thing that will make customary law to continue to apply in today's Nigeria is when a person has died intestate. That is, the man did not continue to uphold his cultural belief maybe after some time, and he died without making any will. If he has died without making any will, and the members of the family did not process letters of administration, which allows certain persons to administer the estate of the deceased person, the property of that particular person who has died will be administered according to the customary law of his place. Let's take for example Mr. A, who is from Yoruba land, lived all his life. He acquired so much property because he didn't believe he would ever die. He decided not to make any will. But suddenly something happens. Despite all his wealth, he did not make any will. Once he passes on, his property will be shared according to the cultural practices of his people. If his customary law states that the first property that the man acquired must go to the first son, then the second property he acquired should go to the second son, and whichever way the customary law of his people states, that is how his property will be shared among his children. The only way this may not apply is when some persons or members of the family has decided to apply for letter of administration. When this is done, the customary law of these people will not apply. Wherever you are living, as long as you continue to express interest that you want to apply your customary law will always apply to you as well. Maybe you are a Yoruba man, for instance, and you are living in northern states. It doesn't matter. As long as you are a native of Yoruba land, the custom and practice of Yoruba people will always apply in the distribution of your estate. So that is how far we can go for today. If you have any questions, you have comments, you can always reach us and make your comments on the box that is available for you to make comments. Or you can reach us on info@lawaccent.com if you have any inquiries you may want to make. Until we come your way again next week, Tuesday at the same time, we ask that you always come and join us.